What happens when the foundational contract of a democracy, that delicate balance of federal power, just vanishes overnight?
Hmm.
I mean, when the threat of war or overwhelming internal chaos or an economic collapse looms large, where does the republic's ultimate strengths retreat?
Well, that is the immense constitutional question, isn't it? And it's answered by Part 8 of the Indian Constitution. It's the mechanism, really, that permits the government to temporarily transform India from a federal union of states into a near total unitary state, almost instantly.
A constitutional backstop.
A constitutional backstop, exactly. Designed to ensure national survival against existential threats.
Okay, let's unpack this immediately, because these emergency provisions, we're talking national emergency, president's rule, and financial emergency, right? Under Articles 352, 356, and 360, they grant the central government immense, almost overwhelming power.
They do.
But what's critical for you, the listener, is understanding not just the power, but the checks. And this is where it gets really interesting, how the 44th Amendment of 1978 acted as a kind of constitutional correction. It stepped in to rein in that immense power and, really define modern Indian polity.
Precisely. We are diving deep into the constitutional architecture that was designed for national crisis management. And our source material for this is the gold standard for the topic. The excerpts we have from M. Laxmikanth's Indian Polity, the 8th edition.
Right.
Our mission today is to distill the essence of this chapter, linking it directly to UPSC previous year questions, and giving you the quickest but also the most thorough route to mastering this complex, high-yield subject.
Welcome, everyone, to the deep dive. Before we jump any further into the three types of emergencies, we have a quick but a really crucial request. This depth of analysis, linking foundational constitutional texts with the historical context of how they were applied. It's only possible with your sustained support.
It really is. So if you find this content useful for your preparation, and we hope you do, we humbly ask you to subscribe to the Simplified UPSC by PPP YouTube channel.
And if you're able, please do consider joining our paid membership. That support is absolutely instrumental in allowing us to continuously bring you this level of super useful, high-quality constitutional content. We really do rely on you, the community, to keep these deep dives coming.
And to all of our existing members, a huge and sincere shout out. Your support is foundational. Thank you for being so instrumental in our continued content creation.
It helps more than you know. Also, if you could just take a second to like this video and share a valuable comment, it helps the channel immensely.
Absolutely. One last thing before we begin. Free notes, and these include practice PYQs. They are available on our dedicated Telegram channel. The link is right there for you.
And for our Legend YouTube members, don't forget that your premium notes with extra PYQs and model mains answers are waiting for you exclusively on our Discord channel. So do join there if you haven't.
Okay, let's get into the mechanics of crisis governance.
The concept of emergency provisions is just fascinating because it forces us to re-examine the fundamental constitutional identity of the Republic. It's not just a set of rules, is it? It's a temporary change in the constitutional character itself.
That's a key observation. That's a great way to put it. When we analyze the structure, these emergency provisions are housed in Part 8 of the Constitution, running from Articles 352 to 360. And this entire section is rightly identified as a unique feature of the Indian Constitution.
Unique how?
Well, it's explicitly designed to empower the central government to respond with speed and authority to extraordinary situations, whether those situations are threatening national security, the political stability in the states, or even the financial health of the whole nation.
Let's quickly confirm the three distinct constitutional articles that define the scope of these powers, just to set the foundation.
Of course. So first you have the national emergency, which is covered under Article 352. This is triggered by war, external aggression, or armed rebellion. Then there's the state emergency, which everyone famously knows as President's Rule. This one operates under two distinct articles. Article 356, which deals with the failure of constitutional machinery in a state.
The classic breakdown of government.
Exactly. And also Article 365, which is about a state's failure to comply with union directions. And finally, you have Article 360, which governs the financial emergency relating to a threat to India's financial stability or its credit.
The most striking element, and it's emphasized heavily in the source material, is this dramatic unitary shift that these provisions trigger. I mean, how profoundly does this actually alter the relationship between the center and the states?
The transformation is total. It's not an exaggeration to say that. During an emergency, the central government becomes constitutionally all-powerful, and the states fall under its effective total control. The Parliament, for instance, gains the power to legislate on subjects that are otherwise exclusively reserved for the states under the state list.
And what's so critical here, and what you need to remember, is that this conversion from a federal structure to a purely unitary one happens without a formal constitutional amendment.
That's the unique part. The Constitution's text itself provides the switch, allowing the system to shed its federal character in a crisis.
So if we look at the mechanics, let's say a national emergency or president's rule is imposed. The legislative function of the state is effectively absorbed by the center. For instance, in a state emergency under Article 356, Parliament or the president can legislate for that state. How is that power practically exercised? I mean, is Parliament really taking up the load of every single state subject?
That raises a crucial practical point. While the source material confirms Parliament can exercise that power, in reality that would be incredibly cumbersome. So the Union Parliament often delegates that legislative power.
Delegates it to whom?
Well, Parliament can confer the power of making laws for the state on the president, or on any other authority specified by the president. This is the mechanism by which the executive wing of the central government, through the president or his delegates, runs the state and enacts necessary legislation while the state assembly is either dissolved or in suspended animation.
So the state legislature's role is functionally replaced by the central executive's direction. This strong central bias, it feeds directly back into that broader description of the Indian constitutional identity, doesn't it?
Absolutely. The Indian Constitution is described as a union of states rather than a federation of states. And that terminology is not accidental. It carries a lot of weight.
What does it imply, specifically?
It implies two things. First, that the Indian structure was not created through an agreement among the states, like in the U.S. And second, that no state possesses the right to secede. This instantaneous ability to shift to unitary control during an emergency, it just reinforces those inherent centralizing aspects of our Constitution. The strong center, single citizenship, integrated judiciary, things like that.
And mechanisms like the All India Services.
And All India Services, yes. All of which always favor centralization. Emergency provisions are simply the most powerful, the most visible expression of that centralizing tendency.
I noted in the reading that these provisions are considered distinctively Indian, unlike so many other constitutional features we borrowed from global models. Why did the framers feel they had to create something so unique for crisis management rather than adopting, say, a strict American federal model?
That's a perceptive observation. I think it comes down to context. While we did draw heavily from various sources, the Weimar Constitution of Germany certainly influenced the idea of suspending fundamental rights during an emergency. The actual operational mechanism was uniquely tailored to Indian anxiety.
The anxieties of a new nation.
Precisely. Post-partition, the overarching imperative for the Constituent Assembly was preserving national unity and territorial integrity at all costs. They deliberately prioritized flexibility and the power to maintain control during internal strife or external threats. They wanted to ensure the survival of the Union, even if it meant temporarily sacrificing the federal ideal. This whole mechanism is a product of our tumultuous birth.
Let's focus now on Article 352, the national emergency. This is the big one, the provision that alters the constitutional landscape nationwide and most drastically changes the relationship between the citizen and the state.
Indeed. The grounds for proclaiming a national emergency under Article 352 are specific, and crucially, they have been refined over time, both politically and constitutionally. Originally, the grounds were war, external aggression, or, and this is the important one, internal disturbance.
And that phrase, internal disturbance, became the source of so much constitutional trauma. It allowed for the misuse that we saw during the 1975 emergency.
Extremely so. The vagueness of that term was the problem. It meant that political unrest, large-scale protests, or even severe law and order situations could potentially be deemed an internal disturbance.
A very low bar.
A very low, very subjective bar. The 44th Amendment Act of 1978 was the direct corrective response to this failure. It replaced that dangerously ambiguous term internal disturbance with the far more stringent condition of armed rebellion.
And that change was vital.
Absolutely vital. It significantly narrowed the scope for invoking a national emergency for domestic reasons. It now demands a tangible, physical, and organized uprising that involves arms, not just civil dissent or political instability.
That distinction between disturbance and rebellion is high yield for any UPSC aspirant, as it shows a direct constitutional amendment addressing a historical misuse of power. So once the president proclaims the emergency, And this can only be based on the written advice of the Union Cabinet.
Another key detail added by the 44th Amendment.
Right, to prevent unilateral prime ministerial action. So once it's proclaimed, what are the mandatory democratic checks on its duration?
The checks are now highly institutionalized. The proclamation must secure approval from both houses of Parliament within a sharply reduced timeline, just 1 month from the date of issue.
And that's a big change. Before the 44th Amendment, this window was 2 months, wasn't it? It gave the executive a lot more leeway.
It did. The reduction to 1 month forces the executive to seek legislative endorsement very quickly. There's no room to dither.
And once approved, the duration is also tightly controlled, requiring continuous parliamentary oversight.
Absolutely. Once it's approved by Parliament, the emergency continues for a maximum of 6 months at a time. And here is the democratic muscle. It can only be extended to an indefinite period if Parliament grants approval for every 6 months of continuation.
Passed by a special majority, no less.
By a special majority. This constant requirement for periodical parliamentary review was the cornerstone check introduced by the 44th Amendment in 1978.
And this stands in stark contrast to the pre-1978 era, where approval often meant the executive could essentially run the emergency for an unlimited period.
Exactly. Before 1978, once the proclamation was approved, it could operate for as long as the executive desired. It was purely discretionary executive control. This 6-month cap, followed by a mandatory renewal, is a transformative democratic safeguard. It ensures that Parliament, the voice of the people, must continuously validate that a state of crisis actually exists.
Now, let's pivot to the immediate and maybe the most visceral impact on the individual citizen, the effect on fundamental rights. We really need to clearly distinguish between Article 358 and Article 359 as the source material lays out these nuanced differences.
Yes, this distinction is crucial, and it's an area where mistakes are often made. Article 358 deals exclusively with Article 19.
The 6 freedoms?
The 6 freedom: speech, assembly, movement, and so on. The moment a proclamation of national emergency is made on the grounds of war or external aggression, the 6 fundamental rights protected under Article 19 are automatically suspended.
The key word there is automatic.
Automatic. No separate presidential order is required. But, and this is a big but, the suspension only operates when the emergency is declared on external grounds, not on the grounds of armed rebellion.
So just to be crystal clear, if the emergency is declared due to armed rebellion, Article 19 is not automatically suspended.
Correct. If the declaration is based on armed rebellion, the rights under Article 19 are not automatically suspended. They can only be suspended if the president issues a specific order under Article 359, which is a separate mechanism we'll discuss next.
And that's yet another critical layer of protection added by the 44th Amendment. It shows a higher sensitivity around suspending civil liberties for purely domestic reasons.
It does. So Article 358 is the automatic suspension of Article 19 freedoms, but only for an external emergency. Now, what about Article 359? That covers the rest of the fundamental rights, correct?
Yes, most of them. Article 359 is a different mechanism. It empowers the president to issue an order suspending the right to move any court for the enforcement of any specified fundamental rights.
Except Articles 20 and 21.
Except the crucial Articles 20 and 21. The real distinction here is that the rights themselves are not suspended, but their enforcement is suspended. And this requires a separate presidential order, which must then be laid before Parliament for its approval.
That's a subtle but massive legal difference. So Article 358 suspends the right itself. Article 359 suspends the remedy for its violation.
Exactly. The state is then immunized from legal challenges for actions taken against those specified rights. When the emergency ceases, or the Article 359 order expires, the right to enforcement revives. However, much like with Article 358, the legislative and executive actions taken during the suspension period cannot be challenged later.
But then came the critical protection for life and personal liberty, what you might call the unsuspendable rights Articles 20 and 21.
Yes. This is arguably the most critical check created post-1975, and I'd say a guaranteed high-yield question for your prelims. The 44th Amendment mandated that the enforcement of rights under Article 20, that's protection and respective conviction for offenses, and Article 21, protection of life and personal liberty, cannot be suspended.
Cannot be suspended by a presidential order, regardless of whether the emergency is external or internal. Full stop.
Why was it deemed absolutely necessary to constitutionally shield Articles 20 and 21 specifically? What was the context?
This goes directly back to the darkest period of Indian constitutional history, the 1975 emergency, and the infamous ADM Jabalpur versus Shivkant Shukla case of 1976.
The habeas corpus case.
The habeas corpus case, yes. During that time, the Supreme Court adopted a seriously restrictive and frankly flawed interpretation of the right to life. The majority judgment essentially held that once the enforcement of Article 21 was suspended by the presidential order under Article 359, a citizen had no recourse to challenge their detention, even if it was illegal or completely arbitrary.
Which meant that if a citizen was illegally detained, they couldn't even seek a writ of habeas corpus.
Precisely. The court, in that moment, failed in its constitutional role as the defender of fundamental rights. It effectively sanctioned arbitrary detentions. The 44th Amendment was a comprehensive constitutional correction to this judicial failure. It was Parliament stepping in to say, never again.
Ensuring that the right to life and protection against arbitrary conviction remains sacrosanct, regardless of the security situation.
Exactly. It ensures that a minimal democratic floor, based on human dignity and due process, is maintained even when the nation is facing collapse.
Moving from the national emergency to the state level, let's look at President's Rule. It's also known as the state emergency or the constitutional emergency. And this provision, Article 356, has attracted more political controversy and judicial scrutiny than probably any other constitutional provision in this entire section.
Oh, without a doubt. It has been frequently labeled the dead letter that Dr. Ambedkar hoped it would remain, yet it has been used hundreds of times, and often it served as a political instrument rather than a purely constitutional one.
The power to impose it stems from two specific articles, right?
Yes. Article 356, which covers the failure of constitutional machinery in the state, and the often forgotten Article 365.
Article 365, which deals with a state's failure to comply with union directions. Can you elaborate a bit on the difference in the trigger mechanisms between the two?
Sure. Article 356 is invoked when the president, based on a report from the governor or otherwise, is satisfied that a situation has arisen where the government of a state cannot be carried on in accordance with the provisions of the Constitution. So this is the broad ground of a constitutional breakdown.
Very general.
Very general. Article 365, however, is much more specific. It is triggered only when a state government fails to comply with or give effect to any directions given by the union government in the exercise of its executive power. It's essentially a punitive measure for noncompliance, which is then automatically deemed a constitutional failure.
Let's discuss the defined grounds for imposition that would be considered legitimate constitutional failures based on the text and subsequent judicial rulings. What are the proper uses?
The legitimate applications typically revolve around structural and political impossibilities. A classic example is a hung assembly, where after elections, no single party secures a working majority and no stable coalition can be formed.
So government formation is impossible.
Right. Or when a sitting ministry resigns after a defeat, say in a no-confidence motion, and the governor exhausts all possibilities of finding an alternative, stable government that can command the assembly's confidence. These are failures of government formation. And of course, the explicit grounds under Article 365 are legitimate, the failure to heed a constitutional direction from the center.
But the contentious history of Article 356 is just steeped in its political misuse. It's often been treated like a sword to dismiss opposition state governments.
The historical record is poor, to put it mildly. We have repeated instances of improper use. One major type of misuse is where the governor, acting as an agent of the central government, makes their own subjective assessment of a ministry's support without allowing that ministry to prove its majority on the floor of the assembly.
And the floor test is the only constitutionally viable measure of confidence.
The only one. And the most egregious examples were seen when the political party ruling at the center changed, leading to these mass dismissals of state governments belonging to the opposition.
The source material explicitly mentions the mass dismissals following the 1977 and 1980 general elections.
Exactly. In 1977, the newly elected Janata Party government dismissed 9 Congress-run state governments. Then, in 1980, the returning Congress government retaliated by dismissing 9 non-Congress governments. The ground cited was merely that the ruling party in the state assembly had suffered a massive defeat in the Lok Sabha elections.
Which is absolutely not a constitutional failure. A state assembly's mandate is completely independent of the Lok Sabha's mandate.
Correct. Furthermore, another improper use is imposing the rule purely on allegations of maladministration or corruption or severe financial exigencies. These are typically issues that should be dealt with through normal administrative or legislative means, not by dissolving a constitutionally elected government.
Because this power has such destructive potential for federalism, 2 major mechanisms were developed to curb it: the Sarkaria Commission and eventually the judiciary itself. What was the core recommendation of the Sarkaria Commission?
The Sarkaria Commission on Center-State Relations, which worked from 1983 to 88, provided the definitive political and academic advice for restraint. It stated that Article 356 should be used very sparingly in extreme cases as a last resort when all the available alternatives fail.
The last resort.
The absolute last resort. This solidified the consensus that the federal balance must be paramount. The Commission insisted the center should issue a warning first and explore all other alternatives before resorting to outright dismissal.
And while Sarkaria provided the political consensus, it was the judiciary that truly cemented the checks in a landmark ruling.
That would be the S.R. Bommai versus Union of India case of 1994. You simply cannot understand Article 356 without this ruling. The Supreme Court effectively adopted and institutionalized the recommendations of the Sarkaria Commission.
And what were the key takeaways from the Bommai judgment? What did it establish?
It established several critical principles. First, the court held that the proclamation of President's rule is subject to judicial review. Second, the proof of majority of the state ministry must be sought only on the floor of the Assembly and not through the governor's subjective assessment.
Taking that power away from the governor's office.
Yes. And third, the central government bears the burden of proving that relevant material actually exists to justify the imposition. And the real game changer. If the court strikes down the proclamation, the dissolved or suspended assembly is revived, and the dismissed ministry is reinstated.
Wow, so it can actually turn back the clock?
It can. This ruling finally gave the teeth of judicial scrutiny to the recommendations of Sarkaria. It turned Article 356 from an executive weapon into a tightly controlled constitutional mechanism.
That makes the Bommai judgment the ultimate check on the misuse of state emergency powers.
It absolutely secured the federal structure, making the dismissal of a state government a far more difficult and accountable political act.
We've covered security and political breakdown. Let's now look at economic crisis management, which is the financial emergency under Article 360. As you noted, thankfully, this has never been invoked in India.
That's right. And the grounds for a financial emergency are very concise. A threat to the financial stability or credit of India. The president's satisfaction that such a threat exists is the constitutional trigger.
So if Article 360 were ever proclaimed, what would be the primary consequences, specifically regarding fiscal federalism and the salary structure across the union?
Well, the central government would assume absolute financial superintendence over the states. The president gains the power to issue directions requiring states to observe specified canons of financial propriety.
Which includes what, exactly?
It includes measures like the reduction of salaries and allowances of all or any class of persons serving either the union or a state.
And can you elaborate on the severity of that power? The source material makes a crucial point about the judicial system here.
Yes, and this is where you really see the sheer magnitude of the crisis that Article 360 is designed to address. This power to reduce salaries extends even to the judges of the Supreme Court and the high courts.
So no one is exempt?
No one. The fact that the remuneration of the highest constitutional officers, the very guardians of the Constitution, can be centrally directed and reduced demonstrates that in the face of an absolute existential financial collapse, no constitutional office is immune from central fiscal control.
Does the parliamentary approval process for the financial emergency mirror that strict one-month rule of the national emergency?
That's a key procedural detail and a good point to clarify. Like the national emergency, a proclamation of financial emergency must be approved by both houses of parliament. However, unlike Article 352, once it's approved, it continues indefinitely until it's revoked by the president.
So there's no 6-month renewal cycle?
Correct. There is no maximum period prescribed for its operation and no requirement for repeated parliamentary approval every 6 months. This reflects the reality that, correcting a deep financial crisis can't really be confined to short, fixed terms.
That slight procedural difference is vital for exam preparation. Now, let's return to the overarching safeguard across all these emergency types. Judicial review. We've discussed how the 44th Amendment was a direct response to the 1975 emergency, ensuring constitutional checks.
Yes, and we saw how the 38th Amendment Act of 1975, which was passed during that emergency period, tried to make the declaration of national emergency immune from judicial review. It was essentially an attempt to create an executive fortress immune from any court scrutiny.
The executive attempting to make its power absolute. How did the Constitution self-correct, and how did the courts ultimately restore the balance?
The 44th Amendment in 1978 decisively deleted that immunity clause, restoring judicial oversight. But the subsequent landmark decision, the one that cemented the power of the judiciary as the ultimate guarantor, was the Minerva Mills case in 1980. This case, while it primarily addressed amendments to fundamental rights and the basic structure doctrine, explicitly confirmed the principle of judicial review over emergency powers.
What was the definitive ruling in Minerva Mills that establishes the check on the executive's use of Articles 352 and 356?
The Supreme Court held definitively that the proclamation of a national emergency is justiciable. It can be challenged in court. And the court clarified the permissible grounds for a challenge. If the declaration is made in malified or bad faith.
Malice.
Yes. Or if it is based on wholly extraneous and irrelevant facts, or if the declaration is deemed absurd or perverse. This ensures that the president's satisfaction is not just a subjective political whim, but it must be based on objective, verifiable facts that can stand the test of judicial scrutiny.
This balance between executive necessity and judicial accountability is arguably the most important feature of post-1978 Indian constitutionalism. It ensures that the use of this extraordinary power remains tethered to constitutional principles, even in the direst of crises.
The courts essentially said, the executive must have the power to protect the nation, but the judiciary must have the power to protect the Constitution from the executive.
We've charted the complex terrain of Part 8, examining the three types of emergencies and the historical and constitutional correctives applied through the 44th Amendment and judicial oversight.
And what this study truly highlights is the inherent tension within India's structure, what we could call the federalist paradox. In normal times, India operates as a quasi-federal system, maintaining the division of powers. But these provisions, they're the safety valve.
The switch.
The switch, exactly. They allow for the almost instant shift to a unitary system when national security or stability is threatened. And this reflects a deliberate core design choice, prioritizing unity and security over a rigid form of federalism.
And the most important development for anyone studying Indian polity is recognizing that the initial constitutional power was dangerously broad. It led to overreach, which then necessitated these external controls.
Right. We saw a definitive shift from discretionary executive control, as seen so clearly in the 1975 emergency, to much greater parliamentary and judicial scrutiny, the requirement for 6-monthly parliamentary approval for national emergency continuation, the constitutional protection of Articles 20 and 21, and the Bommai and Minerva Mills judgments making proclamations justiciable.
These are all critical layers of democratic accountability.
Absolutely.
So let's zoom out for a second and consider how these immediate crisis-driven powers intersect with the permanent administrative structures of the Union. We've seen the hard power mechanism of emergency provisions, the constitutional hammer. But what about the soft power that reinforces central control even in normal times?
That is a great question, and it brings us back to the structure of the All India Services, the IAS, IPS, and IFOS. These services are the permanent administrative backbone of both the center and the states.
Okay.
Their members are centrally recruited, trained, and allocated to state cadres, but their ultimate administrative and disciplinary control lies with the central government.
So, if the central government possesses the ultimate authority to shift the system to a unitary structure during an emergency, and at the same time, it controls the key administrative and police officers serving in the state governments, even in peacetime, that creates a powerful, entrenched pipeline of central dominance, doesn't it?
It creates a seamless continuity. In a crisis, when the governor assumes executive functions under Article 356, the administrative structure of the state is already staffed by officers whose careers are ultimately controlled by the center. The existing IAS and IPS officers can smoothly facilitate the unitary shift that's enabled by the constitutional provisions.
So the All India Services are a subtle but powerful administrative mechanism reinforcing central control,
while the emergency provisions are the overt constitutional weapon.
Understanding how these two distinct systems, the administrative one, which is the All India Services, and the constitutional one, the emergency powers, work together, it paints a much clearer picture of India's quasi-federal structure. It shows that the center is always structurally positioned to dominate.
It does, and it raises an important question for you, the listener, to contemplate for your mains answers. Is India's unitary federal structure less about the division of legislative lists and more about this entrenched administrative and centralized personnel control? It's a connection worth mulling over, linking two distinct areas of your polity study.
We have completed a deeply contextual and I think a comprehensive deep dive into the emergency provisions in Indian polity. You now understand the three types of emergencies, the necessary unitary shift they cause, and the critical role of the 44th Amendment in protecting fundamental rights like Articles 20 and 21.
And alongside that, the crucial judicial check provided by the Minerva Mills and Bommai judgments. You now possess the nuanced understanding of this core constitutional topic, which is essential for mastering Indian polity for your exams.
Before we sign off, we must reiterate our crucial request. This depth of analysis linking foundational text with real-world application is only possible with your support. So we humbly ask you to please subscribe to the Simplified UPSC by PPP YouTube channel.
And if you are capable, please consider joining our paid membership. That support is truly instrumental in allowing us to continuously bring you this super useful, high-quality constitutional content. We really do rely on you, the community, to keep these deep dives coming.
And to all our existing members, one more sincere shout-out. Your support is foundational. Thank you so much for being instrumental in our content creation.
Please take a moment now to hit that like button on this deep dive and share your valuable comment below. That engagement is key to helping other serious learners find this material.
We also want to confirm that free notes, including practice PYQs directly related to this chapter, are available right now on our dedicated Telegram channel.
But for those of you looking for the full premium experience, that means premium notes featuring extra PYQs and model mains answers for complex questions, like those you often see in the UPSC mains examinations. Those are exclusively available on our Discord channel for our Legend YouTube members. We encourage you to join that tier and get access to that comprehensive resource.
Keep digging deep into your preparation. We'll be back soon with another essential chapter. Until then, continue your deep dive journey.